Well, Chuck, thanks so much for joining us today. It's great talking to you, sir.
Always great to talk to you, Ken.
And, there is always something going on in California. I mean, just a week or so after Governor Brown signed a couple of anti-gun measures into law, now we've got the city of Azusa getting ready to vote on an ordinance that could really jeopardize gun stores, right?
Yeah, it's all part of the Legal Community Against Violence local push. They've got model ordinances out there floating around that they occasionally make their way to city council agendas. And NRA and CRPA have had the local ordinance project of their own in place for almost 18 years now, ever since they started this baloney. And we've been very successful in knocking things back. Azusa is just the latest. They were going to essentially require firearm dealers to get a special use permit, which can be very hard to get and very expensive to get. A lot of times they can do things that don't technically outright ban gun stores or any business for that matter.
Mm-hmm.
They have the same model for adult businesses and tattoo parlors and churches sometimes. But in this case, they were going to use a lot of zoning restrictions, require a minimum separation of 500 feet between any gun dealership and a church or a school, and there's an awful lot of churches and schools out there.
Mm-hmm.
Can't operate on commercial properties that abut residential zones. Basically, it's just a dream. The gun ban lobby's dream sheet of things to make it, as a practical matter, to make it impossible for a gun dealer to open up. And there were a number of gun dealers in Azusa that would have been negatively affected by this. So we sent an opposition letter to them early this week, or end of last week, and thankfully they've kind of snuck this under the radar. That's another strategy they seem to be employing. They don't really want us to mobilize the opposition. But we found out about it before it went into effect. It was up for a second reading, second vote last night. And they've tabled it in response to the NRA CRPA letter. So we'll see what happens. It's not dead, but we've brought up a lot of things, a lot of legal issues that the Legal Community Against Violence conveniently forgets to tell these cities
right.
in the materials that they circulate. So now we'll have to see if they decide to push forward in this version or some new version or what they'll do.
Okay. Hey, are there any other cases out there in California right now that we should be paying attention to, Chuck?
Well, with 819 passing and with 144 passing, the two lawsuits that are going to be hot are the Peruta case, potentially some new CCW litigation, and the dealer record of sale fee challenge. When you go in to buy a gun, you have to pay all these so-called fees, but the state law was just changed to allow those fees to be used to prosecute sort of general gun possession crimes, and that's not how fees are supposed to work, particularly fees on fundamental civil rights. When you pay a fee to have a background check done, that's all that fee can be spent on, because that's the only thing that has anything to do with your purchase while you're exercising your right to buy a gun. So when they try and go out and prosecute gang members for possessing firearms, that's a tax if they're using the money that you paid on a fee on a firearm purchase to do that police work. So we have a lawsuit challenging that. But there's really a lot of changes going on with shall issue out here between the NRA and the CRPA, and one of them actually you saw about the Fresno model ordinance or the Fresno proposal to modify their CCW plan.
Yes, we talked about that I think a few days ago here on NRA News, and that is. Go ahead and remind folks though if they didn't have a chance to hear that conversation.
Well, a lot of departments and a lot of politicians. Remember, California, the whole Central Valley is really those are all red counties,
right?
And so there are a lot of areas of California that actually issue concealed weapon permits, licenses to carry. we hear about San Francisco and Los Angeles and all the cities that won't, but a lot of them will. And now, even some of the marginal cities and counties have discovered that with the layoffs that they're having to do and the money that they don't have to put into police work, some of these politicians are actually realizing they need to give more licenses to carry out to folks so that they can defend themselves. So Fresno is the most recent example. Sacramento, something along these lines happened a few months ago with the election of a new sheriff and a lawsuit brought by the folks at the Calguns Foundation that caused Sacramento to effectively go shall issue. And now Fresno is working on it, and they're using a model ordinances that we put together years ago that a few cities had adopted and considered when we first came out with it, that requires the sheriff, and in this case the police chief of the city of Fresno, to issue these permits more freely.
Oh, really? So, I mean, almost in essence, then a shall issue system in a may issue state?
Yes. I mean, and remember, this is a may issue state because each individual issuing authority is statutorily allowed to decide what constitutes good cause. Mm-hmm. So a sheriff can say, hey, good cause is self-defense, and some of them do. A lot of them reserve. A lot of them have more moderate standards, or in the case of like Los Angeles and San Francisco, that's just no issue. You can't have good cause if you have a death threat against you. Unless it's in writing and signed by the person who says they're going to kill you with a phone number and an address, they're not going to acknowledge that as good cause for a license.
Right.
But the tide seems to be changing, and a new bill that the NRA sponsored and got passed this year, SB 610, requires one of the games that cities used to play was they would have you pay all these fees for training or for testing or for whatever hurdles they put up before they made a determination of whether or not you had good cause.
Oh, really?
And by doing that, they would discourage people because people didn't want to spend the money, because they would basically say, well, you can have to do this, this, and this, but I wouldn't bother doing that if I were you, because you're still not going to have good cause even after you spend the money. Mm-hmm. So nobody would submit the application because they were already told, wink, wink, you're not going to get it, so don't bother trying. Now this bill forces the cities and counties to determine good cause first, which means their policies are able to be. We're able to scrutinize those policies much more carefully, because anybody who goes in now is going to get a declaration on why they don't have good cause or do have good cause, and we can look at that for equal protection problems and other constitutional infirmities that we can use in those jurisdictions to try and challenge the laws.
Absolutely. All right. Well, listen, Chuck, glad you could be with us again, sir, and look forward to doing this again very soon.
Absolutely, Cam, anytime.
Chuck Michel, California civil rights attorney, joining us here on NRAnews.com.